The Constitution Bench of the Supreme Court of India came out with another majority judgment yesterday. Remember, on Monday, 2nd January, the Constitution Bench of the Supreme Court had delivered a 4-1 verdict on the demonetization issue. Yesterday, 3rd January, the Constitution Bench dealt with another seminal issue, free speech. Again, this judgment was a split verdict, 4-1. Incidentally, in both the cases, in both the judgments, the lady judge, Justice B.B. Nagarathna, delivered the minority judgment, the dissenting view. Incidentally, her minority judgment, her dissenting view, had drawn greater attention of the civil rights activists who want our constitutional principles to be protected both in letter and in spirit. There is an increase in perception that in both the cases, the majority view upheld the letter of the Constitution, whereas Justice Nagarathna's emphasis was on the spirit of the Constitution. On the demonetization issue, the majority view was that the executive could enact a policy in anticipation of its approval by the legislature. It approved the decision of the cabinet to go for demonetization of high denomination notes in November 2016, which was duly approved by Parliament a few months later in 2017. But Justice Nagarathna held that since it was an extraordinary decision, not a routine matter, the policy of demonetization should have come through Parliament, or at least through the ordinance route, just as it had happened during the previous 2 occasions when demonetization of currency notes had been undertaken, first in 1946 and then in 1978. Justice Nagarathna's stand was that in keeping with the spirit of the Constitution, but the majority of the judges went by the letter, saying that there is no express bar in the Constitution that the executive cannot take decisions first in extraordinary matters. That was demonetization issue. Yesterday's issue was whether those holding public office should be more liable for prosecution than the ordinary citizens. This was with regard to the hate speech. This was like this. When sundry men and women make incendiary comments, they are liable for prosecution through normal process. But when those who are in the limelight, whether they are state actors or non-state actors, whether they are holding important constitutional or party positions, when they make hate-filled comments, they need to be seen through a different prism. As their comments have greater resonance, wider spread among the mass of people. The question was, if a minister makes a hate speech, should the government be liable for action? The majority view said that the minister's view outside Parliament is his personal view. There was no basis to drag the government into the matter. But Justice Nagarathna differed. She said, a minister enjoys a special position and special privileges. When he makes a controversial statement and the government does not distance itself from it, then it should be construed that he is expressing the view of the government. Then the government as a whole must be held accountable. Justice Nagarathna did not exactly provide a specific instance, but let me give an example to corroborate Justice Nagarathna's point. About 3 years ago, a union minister chanted a slogan in a public rally, देश के गद्दारों को, and incited his followers to shout, गोली मारो सालों को. He repeated this slogan several times. Here was a minister who was given an open call for violence, but no action was taken against that minister because he is a powerful man who enjoys the protection of the government. When a minister gets away with inciting violence, then the smaller fries like Kapil Mishra's, Pragya Thakur's and Parvez Verma's, they obviously will easily get away with inflammatory speeches because they also enjoy the protection of the ruling dispensation. Only if the party or the government they belong to is held accountable for their acts of omission and commission, these notorious bigots can be restrained. That is the underlying message of what Justice Nagarathna was saying. But then Justice Nagarathna was just not saying that this rule should only be applicable to the ruling party, the ruling group. It should equally apply to the opposition leaders as well. If an opposition leader or a member of parliament belonging to an opposition party engages in hate speech, incites violence, then that individual along with the party must be liable for prosecution. The party can be spared only if it condemns the action of that individual. Justice Nagarathna is clearly making a distinction between the letter and the spirit of the Constitution. She is trying to uphold the constitutional values. We know, we have many examples before us how rapacious executives in different countries of the world have systematically dismantled the constitutional framework by seemingly upholding the letter of the law while lacerating the spirit behind it. We must salute Justice P.B. Nagarathna for sounding an early warning, for reminding us that the spirit of the Constitution is equally if not more important than the letter of the Constitution, if we have to protect and defend our democracy. Thank you.